Good afternoon and welcome to all the participants. We'll start in a short while. morning, Dr. Stevens.
Morning.
Yeah. I think we'll wait for a couple of minutes more and then we would be good to start. We are expecting few more participants to join in and we can start in 2 more minutes.
Okay.
Yeah, thanks. Vidula, can I request you to kindly stop your screen sharing, and I would request Devanshi to kindly share her screen. Dr. Stevens, can I just request you to unshare the screen? I'll first introduce about Venture Center. I'll introduce you and then you can start your screen sharing.
Gotcha.
Yeah, thanks.
Yeah, I'm just sharing, Pradnya.
Yeah. Good afternoon, all, and welcome all for today's workshop, which is going to be tomorrow also, part of it. It is a workshop on structuring, negotiating, and closing license agreements. Before I hand over stage to Dr. Ashley Stevens, I would very briefly introduce what Venture Center is, what TechX is, and then I would welcome Dr. Stevens to give his lecture. Next slide, please. Venture Center, as I think most of you must be knowing, but those of you who have not been to Venture Center or not aware of Venture Center is a technology business incubator situated in NCL Innovation Park. We are the first technology business incubator to have been incepted in the CSIR family. On the right-hand side, you can see photograph of Venture Center. Next slide, please. So Venture Center is a Section 8 not-for-profit technology business incubator. And as I mentioned, we are the first in the CSIR family to have been incepted. And we were incepted back in 2007. Venture Center is approved by NSTEDB and BIRAC. We are recognized by DSIR and DIPP. We are also CREDAL accredited not-for-profit organization, and we are eligible for CSR funding under our charitable organization. On the bottom of the slide, you can see few of the awards which Venture Center has to its credit. The most recent being the National Entrepreneurship Award, which we received in 2019. Next slide, please. At Venture Center, we have a mission to nucleate and nurture technology and knowledge-based enterprises for India by leveraging the scientific and engineering competencies of the institutes in the region. And the focus areas for our expertise or for the activities that Venture Center carries out, they are like healthcare, biotech, biomed, energy, clean energy, then engineering, electronics, agro. Having said all these focus areas, we are sector agnostic, but these would be the thrust areas where most of our startups are nucleated and nurtured. Next slide, please. Very briefly, I will tell you about TechX, which is a regional technology transfer office situated in Venture Center. And we have a mandate to facilitate technology commercialization partnerships. We are funded by NBM BIRAC, which is a Section 8 company of DBT. Next slide, please. At TechX, as I mentioned, we support technology commercialization journeys, and being a regional technology transfer office, we have a mandate to scout and to promote technologies in the western part of India from the states of Maharashtra, Goa, Gujarat, and Madhya Pradesh. But having said that, few of the activities, we cast a wider net all over India. But most of the services, they are more centered towards western part of India, where we have a strategic partners and we scout technologies from. Next slide, please. Under TechX, we have various services that we offer. We categorize our services into 3 verticals. One is more geared towards technology commercialization. Under that, we offer services for technology marketing, deal structuring under technology transfer, agreements, valuations, negotiations, and we also help in spin-off and new venture creation. The second vertical is all about intellectual property protection. It's decision support and policies that we help these institutes to formulate. We have 3 patent agents in our team who help or who actually deliver these services. We have access to 2 paid databases based on which we offer our search and analytics support services. We also help institutes to formulate their policies, to set up their office in their organization, and how to do innovation management. So all these services are provided by TechX. The third vertical is more about how we cater to industries to bridge the gap between the academia and the industry. So we call it as industry academia partnering. And under that, we have various services like mechanisms, contract management. Then we also do technology scouting and open innovation services for various industries. And on the bottom right corner, these are our coordinates. In case you are interested in availing our services, please feel free to write an email to the given email ID, or you can visit our website also. Not taking much of your time, I would go ahead to introduce today's speaker. Next slide, please. Today, we have Dr. Ashley Stevens with us, and he's going to take 2 days workshop, which is going to be tomorrow also. So Dr. Ashley Stevens, he heads and he's president for Focus IP Group based out of USA. The Focus IP Group provides a variety of consulting services in IP matters, including serving as an expert witness in intellectual property disputes, technology scouting, technology transfer, and teaching the commercialization of early stage technologies. For 15 years, Dr. Stevens led Boston University's Office of Technology Transfer. He then became special assistant to the vice president for research for 2 years before retiring from full-time employment at Boston University. He remains a lecturer in the Strategy and Innovation Department in Boston University's School of Management, where he teaches 2 graduate-level interdisciplinary courses on technology commercialization. Before joining Boston University, he was director of the Office of Technology Transfer at the Dana-Farber Cancer Institute, a teaching affiliate of the Harvard Medical School. During his tenure at Boston University, the Office of Technology Development spun out over 50 companies based on the university's research, a number of which raised substantial amounts of capital, and the university's licensing income climbed steadily. He is a guest professor at Osaka University, Japan, where he teaches GTech and intensive summer course on technology commercialization. He has also taught in Chile, China, and India. Prior to entering the technology transfer profession, Dr. Stevens worked in the biotechnology industry for nearly 10 years. He was a co-founder of Kytogenetics Inc., of which he is still a director, and was co-founder of GenMap Inc., and was VP of Business Development for Biotechnica International. He started his career with P&G, where he held a number of positions in commercial development, sales, marketing, product management, strategic planning, and acquisitions and mergers. Dr. Stevens publishes and lectures frequently on many aspects of technology transfer, including the Bayh-Dole Act, the economic impact of technology transfer, and its role in economic development. The contribution of academia to the discovery of new drugs and vaccines, the role of technology transfer in global health and technology evaluation. He was the recipient of the Bayh-Dole Award at the Association of University Technology Managers, if that's AUTM, in 2007 annual meeting, and became president of AUTM in March 2010. He's also active in the Licensing Executive Society and the MassBio. Dr. Stevens holds a Bachelor of Arts in Natural Sciences, a Master of Arts, and a Doctor of Philosophy in Physical Chemistry from Oxford University. He is a certified licensing professional and a registered technology transfer professional. So today, Dr. Stevens, next slide, please. He is going to talk about principles and practices of licensing. With this introduction, I would now request Dr. Stevens to kindly share his screen and start the session.
Ashley, we can't hear you. Can you just test your sound, please?
Dr. Stevens, you're on mute.
Yeah. Okay.
Yeah, we can hear you now. Yeah.
Good. So thank you, Pragya, for that introduction. It is a little out of date, I have to say. I am no longer a lecturer at BU, so I can date exactly when I wrote that bio, but there we go. First of all, I want to thank everybody who's supporting this, the Venture Center, TechX, BIRAC, and the National Biopharma Mission. So I want to start out by asking the question, what is a license? Well, let's think about cars and driving. Are we born with a God-given right to drive a car on the streets of where we live? Now, our teenage children may certainly think so, but of course, that isn't the case, is it? You need to get permission to drive on the streets of where you live. You need to apply to the government for a driver's license. And they're probably going to give you a driver's license, but they're going to impose conditions on you. You may need to pass a test. You're going to need to adhere to the local rules and regulations. Driving on the left, driving on the right, going the right way around rotaries and things like that. And if you don't meet those conditions, then there is an enforcement mechanism to make sure that you do meet those conditions. So, in other words, a license grants someone access to something, lets you use it. Oops. So obviously the licensor must control the assets that access is being granted to. We apply to the government for our driver's license because the government owns the roads. And therefore, because the government owns the roads, they have the right to grant new drivers access to those roads. They still own those roads. You don't own a little piece of the street outside your house or at your office building. And the owner of those assets can impose their own terms and conditions in return for granting that access. In other words, a license is a bargain or a deal. Let me give you an analogy. Your parents finally insist you move out and you need to find somewhere to live. You basically have two options. You can rent somewhere or you can buy somewhere. Now, if you rent an apartment, the landlord still owns the place. You have the right to live there for some defined period, whatever the term of the lease to the apartment is. You have to pay the rent each month. The landlord probably can stop by whenever he wants to check up on the place to make sure that you're maintaining it, that it's clean, that there's not trash everywhere that's attracting insects and rodents and things like that. And there may be other reasons you can be evicted. Let's say you make too much noise and disturb the neighbors. He may be able to evict you for that reason. Now, on the other hand, if you buy somewhere, you own the place, and you have the right to live there permanently. You've still got to pay the taxes. You can rent it to someone else. You can choose to sell it to someone else. And licensing a patent is like renting an apartment. And the equivalent with a patent of buying the house is when you assign a patent. That's when you sell your ownership of the patent to someone else, and they now own that patent. And I think it is universally accepted around the world that for universities, the best practice is to license your patents, not to assign them. In the US, we have this law called the Bayh-Dole Act. This was the law that allowed universities to own inventions that were funded by government research, government funding, which is 70% of all the funding for research that American universities get. Before the Bayh-Dole Act, the government owned the patents and was truly miserable at licensing them. So this gave the patents back to the US, to the universities, and they could then take control of them. And under this law, we're not allowed to assign our patents without the permission of the agency that funded the research. We can license them freely, any way we like. We can't assign them. And the agencies that fund the research, the National Science Foundation, the National Institutes of Health, the Departments of Defense, the Department of Energy, whatever it is, they've made it very clear that they will not give permission for universities to assign their patents. They will only let you license them. And the argument they make is, hey, if Google, which is what, the fourth most valuable company in the world, can get started based on an exclusive license from Stanford, not an assignment, but a license, why do you need to have the patent assigned to you? And that's a very good argument. And we'll talk a little later about why licensing is better for you than assignment. Another good example to think about is think about the deal between Microsoft and IBM back in, when was it, 1976? IBM was developing the personal computer, and they needed an operating system for it. And they only knew how to make operating systems for great big mainframe computers. So after looking around, they contracted with Microsoft to develop MS-DOS for the IBM PC. They paid them to do it. Now, you might think, okay, they paid them, they own it. But they didn't. They only had a license to use it in their PCs. Microsoft retained the ownership and could license it to all sorts of other computer companies. And of course, what that did was it created a standard operating system, and software writers could now write their software that worked on MS-DOS. And so that class of computer, powered by Intel chips, became the standard operating system. Now, you might say, Microsoft is now worth much more than IBM. Did IBM give up all that value? Would they be worth as much as Microsoft today or more because they have all their other business? Well, I just don't think that other computer makers would want to rely on a competitor for their operating system. And so I think IBM was very smart in letting Microsoft own the MS-DOS and continue to license it to other people, because it created an enormous market for IBM personal computers because so much software got written for them that they became very, very useful. I should also mention that, interestingly, a man called Jack Sam, who negotiated for Microsoft with IBM, he was an IBM employee and he did the deal. He finished up working in tech transfer in the offices of Florida State University. And I'm terribly sorry to say that I always intended to go and meet him and talk to him about his experiences in this negotiation, but I never got around to it. And unfortunately, he passed away a couple of years ago. So that's what a license is. It's granting someone access without selling your ownership of it. But why do you license something? Why do you give up your rights to somebody else? Well, they do it because they can't or they don't want to develop a particular technology. If you're a university, it's not part of our mission. We do research, we publish, we can get patents, but it's not our job to develop products. That's certainly the case in America. I must say, in other parts of the world, in China, universities build factories and use the profits to fund the university's operation. In other places, I've come across universities not trusting licensees, and so they make products. But by and large, universities don't make and sell things. If you're a small company, perhaps you don't have the resources to take this product to market. Maybe it needs very big and expensive factories. Maybe it needs to be sold globally, and you just don't have those resources. Perhaps the invention isn't sufficient to market a product. Perhaps it's a platform technology that provides the fundamental principles, but you need additional inventions to turn it into a product that somebody can buy and use. So the person who owns the technology does a deal whereby somebody else bears the majority of the risk and receives the majority of the reward. And the inventor, who is the licensor, receives part of that reward. In other words, the person who owns the technology is making the calculation that 5% or 10% or 25%, whatever they negotiate, is going to be their share of the finished product. But 5% or 10 or 25% of something is worth more than 100% of nothing, which is what they would get if they retained ownership and control and did it themselves. Or perhaps even they're saying 5% or 10 or 25% of a big pie that this big company can create is worth more than 100% of the small pie that I could create by myself. There are different types of licenses. There's in-licensing, when you acquire the right to develop and sell a product. And these fall in two types: an enabling license, which is both rights to the patents and the underlying know-how that you develop as you start building a technology that doesn't get incorporated in the patents. And then there is freedom to operate, when you just give rights to the patents and people don't have to pay, they have to pay to get through the barriers that have been created by blocking patents that you own. And then there's out-licensing, the opposite, granting rights to intellectual property to others. An enabling license, giving the product to someone else with more resources. And then freedom to operate, extracting value from a platform technology that you own. And then there's cross-licensing, where two entities trade their IP rights. Perhaps they're eliminating blocks that each of them has that could stop the other from getting to the marketplace. And this might be in the same market where they're competing with each other, or they may be in parallel markets where they don't compete with each other, and so they're quite happy to give up rights to their patents to the other. Another way that you look at it is what we call enabling licenses, or a carrot, after that old thing about you make the donkey move by hanging a carrot in front of his mouth and he walks towards it. So enabling licenses include know-how. They're often a collaboration between the inventor of the technology and the company that's going to develop it. These are done at an early stage. The patents probably aren't issued yet. They're still pending. And then the opposite is what is called freedom to operate, or STIC, or assertion licensing. STIC being when you beat the donkey with a stick to try and make him move forward and pull the cart. These are naked. They're just a right to the patents, no know-how. You only do them close to product launch when you're sure that your development program has succeeded and you're actually going to be getting into the marketplace. And the patents will most certainly have been issued. Cross-licensing, as I said, two parties grant each other licenses to their patents. They're fighting to a draw. They were both going after this market. They each got some unique rights, and they realize that they're not sufficient. They need the other's rights. And so what this does, it strengthens both of them versus the competition. They can be royalty-bearing, or they can be royalty-free. They're normally royalty-bearing, and so part of them offset. And one of the things I've found from my work in litigation is that these are cross-licenses are generally done at lower royalty rates than if you're just licensing to a company that doesn't have anything you want back in return. So because you're getting something in return, you ask for less for your technology. And here's a very famous example of cross-licensing. Sony of Japan and Samsung of South Korea are going to share the bulk of their patents. And this was a deal they did almost 20 years ago now, in 2004. Sony of Japan holds about 13,000 patents, while Samsung of South Korea holds about 11,000 patents. So this broadly enabled them to maintain, develop their products, and strengthen them against competition. Now, newer companies try to enter a field. You find them acquiring patent portfolios for defensive purposes. So, a famous example, Facebook. Although Facebook is now the dominant social media platform worldwide, they were only the third social networking site. There was MySpace and Friendster. So Facebook, which I think people tell me succeeded because they had superior privacy controls, was late to the party. Friendster's first patent was filed in 2003 versus Facebook's in 2007. And so Facebook has acquired about 1,500 patents from others, most notably from IBM and Microsoft. And you can see they bought Friendster's patents when Friendster went out of business. And you can see they paid a very large amount of money. I've studied a lot of big purchases and sales of patents, and they often go for about $250,000. And you can see that the Friendster patents, which were fundamental to social networking, went for 10 times that. They went for over $2 million. And lo and behold, Facebook got sued by Yahoo over 10 patents. And because they had acquired this portfolio, they were able to do a settlement with Yahoo, and there was a cross-license of each other's rights and a strategic partnership between the two of them. So I think this shows you how newer companies can use intellectual property creatively to both protect their business and to build their business. So how do we divide up the pie? How do we decide how much the inventor of the technology is going to get and how much the developer of the technology is going to get? And that's the 25% rule. It's a fundamental principle of technology evaluation. It's also called the Goldscheider principle, who was the man who identified this rule and formulated it. And he said the licensor should receive 25% and the licensee should receive 75% of the pre-tax profits from a licensed product. And we will talk much more about valuing technology tomorrow. So how do you get out value in a license? Well, there's all sorts of ways you get money out. You get upfront fees. You get ongoing payments even before the technology, excuse me, is in the marketplace. You might get your patent costs reimbursed. You might get milestone payments. You might get annual minimum royalties. You might get research collaboration and support. And you will get money if the licensee in turn passes the technology on to somebody else by a sublicense. You will expect to get part of that money. And then, of course, there's earned royalties. Royalty payments, there's three basic types of payments. There are fixed lump sum payments, payments that you get as long as the license remains in effect. These are things like the upfront fee, an annual maintenance fee, an annual minimum royalty. Then there are contingent lump sum payments, payments that you get if certain things happen. Things like a patent milestone. You've agreed when a patent gets issued, you'll pay me money. You might agree that if, as the technology is developed to meet certain milestones that show it's going to work, you pay me more. There might be sales milestones if the sales of the product exceed certain targets. If you got shares in the licensee, then when you sell those, that you'll get paid. And if they do a sub-license, then there'll be lump sum payments coming out of that. And these share the increase in value of the technology as it's developed. We'll talk more about this tomorrow. And then finally, you have running royalties. These are payments that depend on the extent of the licensee's use of the licensed technology. If it's very successful and their sales are high, then you deserve more money than if it's less successful and their sales are low. And you can see some of these payments are made even before the technology gets into the marketplace, and some are made after the technology gets into the marketplace. So the upfront payments, cash fee, sum of money when they sign the agreement, often includes the patent costs that you've invested. For academic institutions, patent costs are a very, very important element because you have all these inventions coming along. You don't know how many are going to be successful, and you have to pay the patenting costs on all of them, and only some of them are licensed and get you your money back. And this upfront fee reflects the initial value of the technology being transferred. And as we'll talk about tomorrow, that upfront fee, the initial value of the technology, is probably going to be pretty low because you don't know if it's going to work and you don't know if people are going to want to buy the products at the end of the day. And if you're dealing with a new company that's got no money, then they may only be able to pay you with shares in the company. And in America, when you license, a university licenses to a startup company, they always get shares in the company, and some of those become quite valuable. When Stanford sold the shares it got in Google, they got $350 million for it, a lot of money. Ongoing pre-commercial payments, well, you'll expect your patent cost to be reimbursed if you're a university for sure. And I talked about milestone payments, payments that reflect the increase in the value of the technology to the licensee as they make progress. Now, this may sound kind of weird. They're investing in the technology and making it successful, and you still expect to get paid when I'm spending the money? The answer is yes, because I didn't charge you much up front. I accepted that the technology wasn't worth that much on the day I transferred it, but as the value gets proven through your development efforts, then you can start to share some of that increase in value with me. And this is particularly common with life sciences inventions because everybody knows what like phase 1 testing is. The drug gets into phase 1 testing. Everybody knows what that is worldwide. And so the technology, the drug, the diagnostic test, whatever it is, has obviously got an increase in value. And so share some of that value with me. Patent milestones might be important, sales milestones. And then there are annual minimum royalties. Now, these also act as a due diligence mechanism. If the company has lost interest in the technology, they're not going to want to pay you an annual fee to retain the rights. So this will make them give it back to you if they've lost interest, and you can then find somebody else who might be interested. And these typically escalate substantially after 3 or 4 years. And we'll look at an example tomorrow. And these are more common with physical sciences inventions. And the reason is that the development milestones often aren't as clearly defined as they are with things like clinical milestones. You're developing software. When does an alpha test become a beta test? You could argue about that, and you don't want to be having arguments with your licensees down the road. Sublicense income sharing is a very important topic, particularly when you're licensing to brand new companies. The challenge is that you need to negotiate the terms of this years before that sublicense happens, because your licensee can only sublicense after they've started developing it, got some way down the pathway, and then they take on a partner. So you don't know what the sublicense, how it will be structured. You don't, and the university's objective is going to be to ensure that the licensee can't game the system by structuring the sublicense to minimize what it has to pay back to the university. The solution is the university gets a piece of every payment that the licensee gets from the sublicensee. Licensing guy for the University of Pennsylvania in the US, Lou Berneman, once said, "You will pay me every which way there is." Now, there are certain exclusions for things that are deliverable, like if they're going to pay you to do research support or they're going to buy stock in you, you don't get a piece of those necessarily. There are 3 models for how a university shares in the income that its licensee gets from sublicensees. The first is what we call a pass-through. The university gets the same running royalty on the sublicensee sales as if the licensee sold the product. Plus, they get a set percentage of every payment received other than running royalties, which you sometimes see termed non-royalty income. And the reason that this, the intellectual justification for this is, well, we've agreed that if the licensee sells the product, I'm going to get 5%. So why would I get anything other than 5% if somebody else sells it? The allocation is the university gets a set percentage of every payment the licensee gets from the sublicensee, including the running royalties. And the reason for this might be that they say, look, I don't know how much I'm going to get. Supposing I agree to pay you a 5% royalty, and when I do a deal in 10 years' time, I can only get a 10% royalty. So I'm going to pay half to you. So let's agree I'll give you a percentage of every payment I get. And then a tiered allocation is the university gets a lower percentage of payments received from the sub-licensee before commercialization and a higher percentage of the running royalties after commercialization. And this allows the company to use the payments it gets from its sub-licensee to develop its technology and have to raise less money from the outside world. And the percentages may be based on the timing of the sub-licensing after the license is executed. If you sub-license in year 1, I get 25%, in year 2, 20%, year 3, 15%. The thinking being that the longer it goes, the more the licensee has invested. And so less of the value they're getting comes from what they got from the university and more from their own efforts. Running royalties, which you also see called earned royalties, these are the main post-commercialization economic component of the license. They have the biggest long-term impact if the product is successful. And they're an equation. The royalty payments are the royalty base times the royalty rate. And they're made for the duration of the royalty term. So what's the royalty base? This is the measure of how much the licensee is using the technology. You might say, well, the number of units you sold is a measure. You might say your sales are a measure, or your profits are a measure. You do see licenses written in terms of profits. I don't think university licenses are done in terms of profits very often. In fact, very, very rarely. And if you do use profits, you need to define them very, very carefully. Are you going to be based on gross profits, net profits, profits after taxes? And one of the reasons that you don't use profits very often is that they are very difficult to audit. There's a lot of numbers that your auditor is going to have to measure and verify. And the more work the auditor does, the more they're going to charge you. The most common definition you come across is net sales. This is the gross sales of the company less either standard deductions for things like shipping, insurance, returns, or a standard deduction, typically 3 or 5%. And that's because the cost of shipping and insurance and things like that aren't reflective of the value of the technology. The royalty rate is how much of the licensee's return from using the technology the inventor of that technology, the licensor, is going to get. And the royalty rate can either be flat, in which you get the same royalty rate for all sales, or it might be tiered, in which the royalty rate is different at different levels of sales. And tomorrow we'll talk about how the royalties should change with sales. Basic marketing theory says that the bigger selling products are more profitable. And basic royalty theory, the 25% rule, says the royalty rate should therefore increase at higher sales levels. The royalty term is how long you're going to get paid. Universities usually use the last to expire patent on a country-by-country basis. My experience from litigation has been that companies frequently use the longer of the last to expire patent on a country-by-country basis, or 10 years from first commercial sale, again, on a country-by-country basis. Since patents typically have a lifetime of 20 years from the initial date of application, what this formulation is saying is that if the development of the product takes longer than 10 years, so that I would get less than 10 years of royalties on a patent expiration basis, then the 10 years from first commercial sale protects me to get a standard return. And I don't know why more universities don't use that formulation. It's certainly in the standard form of license agreement that I use. So here's an example of a license. The license issue fee, $50,000. Annual minimum royalties, $10,000 a year in years 2 to 4. You don't get an annual minimum royalty in the first year because you got your license issue fee. Then they go up to $25,000 for years 5 to 7. And then they're $50,000 a year thereafter. Milestone payments, $50,000 in year 3, $100 in year 4, $250 in year 5, $500 in year 6. A royalty rate of 5%. Sunk patent costs of $75,000. That's money you'd spent before you got the license. And then annual patent costs of $10,000 to $25,000. Let's assume these are the product sales. Product sales start in year 7 at $750,000. They climb. They reach a peak of $25 million in years 13, 14, and 15, and then they start to decline. Here is how the flow of money would look under those license terms. The green are the patent cost reimbursements. The blue are the fixed lump sum payments, and the red are the running royalty payments. And you can see something leaps out at us from this, doesn't it? First of all, the milestone payments, the first ones are low. Only the last milestones here and here, close to product launch, are remotely close to any of the running royalty payments. And the second thing you see is obviously the bulk of the money you make is from the running royalty payments. What this says is in your negotiation with the licensee, you should do that negotiation assuming the product will be successful and focus on the late stage milestones and the running royalty provisions, not on the early sums of money up here. Now, you sometimes come across what people talk about the value of a license. And that is a sum of all the lump sum payments. And in the life sciences area, you see this called biobucks. It doesn't include royalties on product sales, and it assumes that every possible product will be successful and will hit the maximum sales milestone targets. So in our example, the value would be $1,055,000. That's the sum of all the lump sum payments. So here's an example from quite some time ago, 2008. Amgen gets a lift in a deal with Takeda, and they say it could be worth as much as $1.19 billion plus royalties. So that is the sum. $1.19 billion is the sum of all the milestone payments they've agreed. It doesn't include running royalties. Royalty audits. Now, the licensee is going to report to you how much they owe you, whether they're going to pay you quarterly or semi-annually or annually. And by and large, you want to get paid quarterly. And you remember what we talked about, the enforcement mechanism in a license? Well, a key part of any license agreement is the ability of the licensor to check the licensee's calculations. And that's called a royalty audit. You must include the right to audit in your agreement. The licensee, the auditor will check the sales. They'll check the deductions. If there's any offsets or stacking of royalty rates, they'll check those. In the immortal words of Ronald Reagan talking about the Russians, trust but verify. The audit is how you verify. So that's a lot of the philosophical aspects of licensing. Now let's talk about some of the contractual aspects. We talk about a license as being a marriage. You're creating a relationship which, if successful, will last 20 or more years. And like a marriage, it'll probably be quite expensive to get out of. Now, the relationships in a license are unequal. The licensor has made their investment. They don't want to spend anymore. They're looking for a return on that investment. And the licensee is taking on the substantial risk of the future development, the financial risk, and the opportunity cost. A company can only work on so many things, and if it works on your technology, it can't work on something else. So these are the elements that you see in a license agreement. And now we're going to go through and talk about each of these. The recitals, these are the clauses you see at the beginning of a license agreement, the whereas clauses. They establish the background to the current agreement. They establish the purpose and the objectives of the party. They're actually non-binding. If there's a discrepancy between something that's in the whereases and something that's in the agreement itself, then what's in the agreement itself is what will be applied to the situation. Definitions are enormously important. In a license negotiation, you should probably spend half of your time on the definitions. And defined terms are either capitalized or they're in all capital letters. I don't like all capital letters myself because it makes it very disruptive to read a sentence in which periodically you come across words that are all caps. I like just to initially capitalize the definitions. And you have a section of definitions, either Article 1, right up front, or an appendix. And so you will see something like licensed patents, and you can see the L and the P are capitalized, shall mean. Some terms are defined in the text. And if you do that, you put them in parentheses and quotation marks. So this license agreement dated as of June 30th, 2012. And then we define June 30, 2012 as the effective date by and between the trustees of Boston University. And instead of saying trustees of Boston University, every time we want to talk about the owner of the technology in the text, we're just going to say university. So we've defined university to mean trustees of Boston University. Complex agreements between companies, late stage agreements when the technology is close to market, they can have 200 defined terms. University licenses, you're probably going to have around 20, 30, 40 defined terms. Now, the license grant is the very important section of the license. It defines the rights that you're going to grant. And you can grant different degrees of rights. On the left-hand side, you have the complete transfer. You sell the technology. And I said at the beginning, that's called an assignment. On the other side, you grant no rights, but you just promise you won't sue them. You've all heard, if you're in life sciences, of polymerase chain reaction, PCR. That was an enormously important technology when it came out. And it was invented by Cetus, and the rights were owned by Roche. And they charged a 15% royalty for use of PCR and an extra 3% if you bought your enzyme from somebody else. For that, you didn't get a license. They just granted you a freedom from suit. And then in the middle, you have this limited transfer of rights, a license. And you might grant exclusive rights in which you say, okay, you are the only company that can do this, and even I won't do it. Or they might be non-exclusive rights in which you say, I'll give you the right to do this, but I'm going to give lots and lots of other people the right to do it too. And then in the middle, you could make it exclusive by field of use. This company gets the rights to use it as a drug. This company gets the rights to use it as a veterinary drug. This company gets the rights to use it for diagnostics. Or you might do it exclusive by territory. This company gets the rights to the technology in Asia. This company gets the rights in Europe. This company gets the rights in North America. So licensing I characterize as being like a scalpel. You can slice things as thinly as you like. Assignment is like a sledgehammer. There's no subtlety. You've given up all your rights to somebody else. I said we'd talk a little bit about why you license rather than assigning. As I said, in the US, we don't assign because we're not allowed to by law if it's been federally funded. Other countries don't have this protection, and we do find universities come under pressure to assign. Now, you can write an assignment agreement with the same payment terms as a license. So why is an assignment less attractive? The difference is in the balance of power if things go wrong. A licensor can terminate the license unilaterally. You can write to the licensee and say, you did this breaches the license, I'm terminating. They may object, but you take the action, you've got control. An assignee has to agree to assign the license back, the technology back to you. If you've signed it over to them, they now have to sign it back to you, and you're undoubtedly going to have to go to court to force them to do it. So one of the things you're going to have to do is decide how you're going to license it, exclusive, non-exclusive, by territory, etc. So the fundamental question is, are you going to license this to an existing company or a new company? And you find that truly revolutionary inventions frequently need a new company. You know, Stanford agreed to license Google to Brin & Page because they couldn't license it to any of the existing internet companies at the time. And so that's why they said, okay, go develop your own company. Whereas incremental inventions are licensed to existing companies. Next thing you need to ask are there multiple products that come from the technology? The answer is yes. Which market is most attractive? Do you need separate sets of patent claims to protect each market? Are the products used in the same industry? If so, can the same company exploit them? The answer to either is no. Then you're going to need to license by field of use and find multiple licensees. Does the license need to be exclusive? That certainly maximizes the incentive to the licensee. They know that if they're successful, they'll be the only one selling that product. But it maximizes the risk to the licensor. If they mess it up, then you're done, you're cooked. Which is why you have in exclusive licenses due diligence milestones in which the licensee has to commit to get to certain stages in development by a certain time frame. And exclusive licenses generally have higher royalty rates than non-exclusive. The rule of thumb is 2 times that a non-exclusive license, if it's worth 3%, if you granted an exclusive license to that, you would get 6%. Does the technology provide everything that's needed for a finished product? If so, do you want to give the maximum incentive for the licensee to invest in developing the technology? Exclusivity does that. Is there a clear market leader? They may be the most attractive or even the only viable licensee. Or is it a crowded market? If so, the second or third company in the market may be a more motivated licensee. They may say, hey, this is what I need to finally beat those guys who've been dominating the market all these years. Avis in the US years and years ago used to advertise, we're only number 2, we try harder. They eventually realized that they were advertising for Hertz each time they said that, so they don't say that anymore. In the US, universities grant about 20% of their licenses to startup companies, and that percentage has been going steadily up over the years. 50% to existing small companies. Now, I need to explain what a small company is in the US. There are various government programs to support small companies in the US. The Small Business Administration, you can get loans, you pay lower fees at the patent office, things like that. And the criterion to get to be considered a small company is 500 employees or fewer. Now, in most countries, 500 employees is medium, not small. So whereas a lot of people talk about SMEs, small and medium-sized enterprises, as opposed to big companies, in the US, we just talk about small companies. A lot of our small companies would be medium elsewhere. And then about 30% of our licenses are done to large companies, companies with more than 500 employees. About a third of our licenses are exclusive these days, and startups almost always need an exclusive license to all fields of use. And then about 2/3 are non-exclusive. And then you need to say, what are the key steps the licensee needs to do to get a product into the marketplace? Because getting to those steps and agreeing the time that they will take to get to those steps become your due diligence milestones and due diligence mechanisms. And you should have at least one milestone per year so that you can check that the company is making progress. And perhaps you need to have more than one milestone in the first year. And these are to ensure that the licensee is developing the technology and to terminate the license if not. And if you're licensed to a startup, you need to include corporate development milestones. You need to make sure they've raised enough money to be able to develop the technology, that they've got the right people they need to develop the technology. You want to think about the value chain for your product. Where in the supply chain does your technology fit? How far forward in the supply chain does the technology's value let you integrate? Because the further forward you go, the more value you capture. So let's say you invent a new material. Well, you could sell that material. You could make subcomponents and sell those. You could assemble those subcomponents into a finished device and sell that. And most supply chains have been so disaggregated, you can usually find a contract manufacturer. Here's an example we did in my course in Japan. This university had invented an improved material for the anode of an X-ray tube. So the supply chain options are to make the material and sell it to anode manufacturers, make anodes and sell them to X-ray tube manufacturers, make X-ray tubes and sell to X-ray system manufacturers, or make and sell X-ray systems to healthcare providers. So the supply chain realities we found were there's only a few manufacturers of X-ray systems, and they're really, really big companies. There's only one manufacturer and seller of X-ray tubes, and only one manufacturer of anodes. Here's what the market looked like. Here's the manufacturers of X-ray machines. Here's the manufacturers of X-ray tubes. There's Varian, who sells to these four, whereas GE, Toshiba, and Siemens make their own tubes. And there's only one X-ray anode manufacturer, that's Plancy in Austria, who sells anodes to everybody. So your only strategic options, if you've invented an X-ray anode material, is to make anodes and sell to the four tube manufacturers, or to make the material and sell to the one anode manufacturer, Plancy. So your licensing strategy would be to determine whether the tube manufacturers are happy with Plancy. And often monopolists can build up ill will, and buyers from monopolists are very anxious to get a new supplier. If they are happy, then the only option is to sell to Plancy. If they're not happy, then there may be an opportunity for a startup anode manufacturer, depending on just how good your new anode material is. We talked about the license grant. Here's the kind of words. University hereby grants an exclusive license, so capital E, capital L, that's defined, to make, have made, use, have used, sell, have sold, and import licensed products, defined, under the patent rights, defined, within the license field, defined. So this definition refers to what? 1, 2, 3, 4 other defined terms. What about sublicensees? Well, don't require prior approval if the exclusive licensee wants to sublicense. And if we're a university, we don't get exclusivity for know-how, which we call technology. And universities don't have trade secrets. Everything has to be publishable. And you may not include the right to improvements, although licensees normally want improvements. And if so, you do it for about maybe no more than 3 years. The licensed patents, this is what the rights are being granted to. You identify them by the number and the title and the inventors. And you need a mechanism, since you're probably doing this very early in the patent family's lifetime, to make sure that follow-on patents and foreign patents are captured within the definition. The license field, or the field of use, this is the subset of all the possible uses of the technology that the licensee is getting rights to. You need to state what is affirmatively included and state what is affirmatively excluded, which would be any planned or previously granted fields of use. And you want to reproduce the exact wording of any other affirmative grants. So, license field shall include all products intended for human, therapeutic, and prophylactic use, excluding any products in which a DNA construct is introduced into a human patient using a viral vector or by direct injection of a gene DNA construct, which we're going to call gene therapy. And that means that you want to or have already done a gene therapy license. And furthermore, should exclude all products intended for non-human animal therapeutic and prophylactic use, which we're going to call veterinary uses. And that means you're going to take advantage of the fact that this disease occurs in animals, and that there are different companies these days that sell veterinary drugs. 30 years ago, the big pharmaceutical companies all sold veterinary products too. They've since divested them. So if your drug has relevance to animals, you need to exclude that. Territory, don't include more than they can reasonably sell in their territory. You do the major territories: US, Europe, Japan, China, India. And then you need to think about, is this a technology that is going to be important in manufacturing or in selling? And pick the countries appropriately. The fees, royalties, and payments, royalty base. Kit deduction, that's if you sell your product in combination with something else. You need to apportion the net sales in the ratio of the individual prices if the products are sold separately. If they're not sold separately, it's very difficult to know how to apportion it. And you may just need to say, hey, we're testing for 3 things in this diagnostic test. I'm going to apportion 1/3 of the value of those sales to each of those things we're testing for. I think manufacturing cost is a terrible way to do it. I think apportion equally. And if you specify we'll negotiate in good faith, that probably means you'll finish up in a lawsuit, because there's very little good faith when money is sitting on the table. The royalty payment is the royalty base multiplied by the royalty rate, less any offset or stacking, less deductions for like annual minimum royalty payments, then you can deduct those. You want to limit the stacking and deductions. And non-exclusive licensees may demand what we call a most favored nations clause. If you give anybody else a lower royalty rate, then I get that lower royalty rate too. Nobody gets a lower rate. Licensed products, you either identify these by name. This is generally if you're doing it at a late stage when the products are known. And if you're doing it an early stage, products which are covered by a valid claim, defined term, of a licensed patent, defined term, or any product which would, but for the license granted hereunder, infringe a valid claim of a licensed patent. And these are legally defined under the patent statutes in the US. Patent prosecution infringement. Our policy was always to control prosecution because our interest might be different from the licensee's interest. And then they get to reimburse the patent expenses. The law firm bills the university bills the licensee. The only time we went away from that was if we thought the licensee might be running out of money, in which case we would let the law firm decide how much credit to give them. Exclusive licensee will want the first right to sue for infringement. The university has to join the suit usually because we retain enough rights that they can't sue in their own name. And infringement costs are paid by the company. And then if there's a recovery, then the university gets some fraction of how much money the company gets from the suit. University usually has the second right to sue, and if the company doesn't want to, and if they do, we keep all the proceeds. Non-exclusive licensees have no right to sue, and they have no right to demand that the university sue. Obligations of the party, reports. You'll want your licensee to report to you on the product developments that they've done, how far they've got, have they met due diligence milestones, and then when products sales start, you'll want to report quarterly their sales of products and their royalty payments. You'll want to specify how long they have to keep their records for auditing. Typically, that is for 3 years, because that's as long as in the US, the tax authorities require companies to keep their detailed business records. You'll want them to report on have they met their diligence standards, because if you license exclusively, that guy is the only person who's going to get you revenues. So you'll want to specify best efforts to develop and commercialize licensed products. Best efforts is a legally defined term, and they may specify commercially reasonable efforts. And then you'll want to specify specific milestone events. They'll get to this point by this stage, and there may be a payment associated, or there may not be a payment associated. In the US, we have to require them to manufacture substantially in the US. That's a provision of the Bayh-Dole Act. You may not have to. You're going to require them to put patent or copyright or trademark notices on the products. There'll be a section on representations and warranties. Very, very important. These are the guarantees you're giving. Universities only represent that they have title to the patent rights. They don't even specify we have complete title, because there may be additional inventors we didn't know about, a graduate student who wasn't named on the patent. And you make no other representations by the university, including whether you can practice the patents without infringing third parties. You certainly don't guarantee that the technology will work. And you will see that these disclaimers of liability have to be in all capital letters and no smaller than 12-point scale. That's a requirement of US law. Indemnification. The licensee has to accept all liability for their use and any sub-licensee's use of the licensed products. And they have to indemnify the university, i.e. promise that if the university gets sued, they'll defend them and they'll pay any money that gets awarded against the university. And you'll require them to have product and other liability insurance, usually required. I'll give you an example. Memorial Sloan Kettering Institute licensed a hepatitis B treatment to a company. They developed it, did a phase 1 trial, and licensed the product to Eli Lilly to do phase 2. In that phase 2 trial, 10 people died and 8 people needed liver transplants, a catastrophe. Obviously, all sorts of lawsuits. The indemnification was so great, so well done, that Lilly bought all the costs. The small company didn't pay anything. They went on and were successful with something else, and Memorial Sloan Kettering was not sued. That's how important this indemnification and insurance is. You often let the large companies self-insure, and small companies, you will require them to take out an insurance policy. And that's the Eli Lilly case I told you about. Confidentiality, the publication, the reports, patent prosecution, other information exchange is going to be confidential. The licensee has to accept all that. Oops, what have I done there? I went backwards. University retains the right to publish its research related to the patent rights. Term and termination, we talked about this. The longer of the last to expire patent included with patent rights and 10 years from first commercial sale on a country-by-country basis. The licensee is free to terminate the license at their option. They decide it doesn't work. They decide it's not good enough. They change their corporate strategy. You can't require them to keep developing the technology. They can terminate with typically 3 or 6 months notice. There might be a termination fee. You certainly want them to return the product, including all the know-how they've created, so that you can find another licensee. They'll probably bitch at that, but your argument is, look, you've consumed part of my patent life. I can't get it back. That's the compensation I get, that if I can find somebody else to develop it, they don't have to start from scratch. They can start from where you got to. The termination by the university will only be if they breach the license agreement. They don't make a payment, they don't meet the due diligence milestone, things like that, or if they go bankrupt. And if they do that, and they've sublicensed it, and the sublicensees are in good standing, then you're going to have to agree to step into the sublicense agreement and replace the licensee. If you don't do that, then they'll never be able to do a deal with another company. And they get a fully paid up perpetual license after the expiration of the royalty term. Now, there'll be disputes. How do we resolve those? Normally, there are steps: a summit meeting of the CEOs, mediation, which is a voluntary process, not binding. There can be arbitration, which is a private trial, which can be binding or non-binding. Usually, if you're going to go to that expense, you make it binding. Or there can be no dispute resolution mechanisms. You go straight to court. Some of the miscellaneous provisions: who gets notice? The university doesn't want its name used as an endorsement of the company's products. Governing law. New York State is a very popular choice for international agreements, even between two countries other than the US. Then often you specify New York State law. Can the company assign the license to somebody else? Do they need permission? Normally, you allow them to assign without permission to an acquirer of the entire company or of the entire business line to which the license behaves. Some of the best practices and lessons learned: start with a good template. Everything is in there for a reason. The licensor should do the first draft, starting from the template. And I have developed a set of template agreements, a term sheet, an option agreement, licenses, things like that, that I'll be happy to make available to the Venture Center to give out to people to use as starting points. They're obviously based on US law. They'll need to be tailored to Indian law, but I'm happy to share those. Now, finish up the story. Here's a book I read 50 years ago. It's called Throw Out Two Hands, And it's written by a journalist who, with two other men, tried to use a helium balloon to fly over the game herds of Africa on the philosophy that the helium balloon is the only way you can observe game herds without them knowing they're being observed. Now, the whole thing was a catastrophe. Nothing worked. But in it, he made the statement that the safety rules of ballooning are essentially a recapitulation of the accidents that have happened. And the safety rules of licensing are a recapitulation of the accidents that have happened. A university license agreement will be, as I said, 15, 20 pages. A company license agreement might be 100 pages. And all those clauses are in there for a reason, because once, somewhere, something went wrong. So I'll give you an example of one of the longest running license agreement I know, which is the mouthwash Listerine. I don't know if you have that in India. It's a yellow, medicine-y tasting mouthwash, very famous. It was invented in 1881 by a doctor in St. Louis. He licensed it to a pharmacist, Jordan Lambert. He licensed him a trade secret formula. Lambert founded the Lambert Pharmacal Company to develop it, and they sold this product, Listerine. And here's the entire agreement. Know all men by these presents that for and in consideration of the fact that Dr. J.J. Lawrence of the city of St. Louis, Missouri, has furnished me with the formula of a medicine called Listerine to be manufactured by me, that I, Jordan W. Lambert, also the city of St. Louis, hereby agree to, for myself, my heirs, executors, and assigns to pay monthly to the said Dr. J.J. Lawrence, his heirs, executors, or assigns, the sum of $20 for each and every gross of said Listerine hereafter sold by myself, my heirs, executors, or assigns, in testimony whereof I hereto set my hand and seal. That was it, 1881. Well, the formula, the trade secret formula, was actually published in the 1930s and 40s. In 1959, Lambert merged with Warner Hudnut to form the Warner Lambert Company, which get finished up being bought by Pfizer. And Warner Lambert stopped paying royalties. They said the trade secret they bought was no longer a trade secret. So the heirs of John Lawrence sued, and the judge agreed. The judge said, the agreement says, as long as you sell, you pay. It doesn't say, as long as it's a trade secret, you pay. So that's why license agreements now are much more than the half page that Lawrence and Lambert used back in 1881. The safety rules of licensing are essentially a recapitulation of the accidents that have happened, and a good starting point template is really, really important. So that's the end of the prepared remarks. I think we have a few minutes left for questions. I see some in the chat.
Yes, hi, Ashley. I'll help you with the questions, me and Pragnya.
Okay.
Yes, sir.
Yeah. So Pragnya, you can go first if you want, and then we can take it from there.
Yeah. So there were two questions. One is, can you provide some example of freedom to operate in licensing?
Oh, sorry, so examples of what?
Can you provide some example of freedom to operate in licensing?
Ashley, I think you had an option where you described how a patent would be used to provide freedom to operate rights. I think that's what.
Yeah. This was from the beginning of the session.
So every license is granting freedom to operate. Okay, you're saying, I've got these rights, I have this control, it's a patent, it's a copyright, it's a trademark. I'm going to give you the right to practice under that. So I'm giving you freedom to operate. Now, the contrast to freedom to operate was when you include know-how, when I'm going to show you how to use the patents. If I grant freedom to operate, I'm not going to tell you anything. You can read the license, the patent, and I won't sue you because now you have a license. But I'm not going to tell you how to practice that patent. In a enabling license, you include that know-how. I'll tell you everything I know about how to practice that patent. I'll give you all the data I've accumulated up to now that you can build on. That's the distinction.
Yeah.
Okay.
Pragya?
Yes, sir. Yeah. I have another question. This is regarding milestone payments. So the participant has asked that value of technology is in terms of potential market acceptance, in terms of its applications or technological performance.
So the lump sum payments reflect the increase in value of the technology as it gets closer and closer to the marketplace. We still don't know how successful it will be. And that's why you have the running royalties. So that if sales are very high, you get paid a lot of money. Whereas if sales are low, you don't get paid as much money. That's why we have both lump sum payments and variable payments that depend on the extent of the licensee's sales of the product.
Yeah, there's a question here on what are the major criteria to be considered while granting exclusive license to a party?
Well, that's a very, very important question. And you've got to be convinced that A, they're committed to the technology. Second, that they have a reasonable probability of success, that they're going to be able to raise the money they need. Or if they're a big company, that they've already got the money they're going to need, that they've got the right people to do the development work, that they've got the right distribution channels to sell the product. You just need to get to know the licensee before you agree to grant them an exclusive license. Now, I will tell you, the rate of success in licensing university inventions in the US is we only license about a quarter of the inventions that are disclosed to us. And we only file patents on about half of the ones that are disclosed. So we license about half of the patents we file for. So there's a great tendency, the moment a company puts their hand up and says, I want to develop this, that you say, whoopee, I found somebody, and you go ahead and negotiate with them. You need to be sure that they are committed and they have either got the resources or a realistic prospect of getting the resources to be able to be successful. Because if you're giving an exclusive license, they're the only person who's going to be able to make any money for you.
There's another question here which refers to a situation where there's a company funding research in a research institute through an agreement. But at the time, I mean, I suppose the terms for patents were not probably written up, but during the filing of the patent, the company wants exclusive patent rights and the institute wants to keep some rights with them. So how does one deal with such situations is the question.
So first of all, one of the principles we have in the US is that we will never grant such an exclusive license that that our researcher can't continue working on the science himself or herself, okay? We always retain those rights. And companies in the US have learned to accept that. But then they might say, well, okay, if I let you keep on working on it, then I want the benefit of any improvements you make. And so you go through this negotiation, and the resolution we normally have in the US is that we'll give rights to improvements for no additional cost for 3 years. Now, most research agreements between companies and universities give the company an exclusive option to an exclusive license to be negotiated in good faith when the invention's been made. And normally that will be for the duration of the research and perhaps for 3 or 6 months after the completion of the research. Now, the company may say, but I want to know how much it's going to cost me. And we actually can't do that in the US because of tax laws. You may be able to under Indian tax laws. You say, okay, if it's successful, I want a 5% royalty and these sort of milestone payments. You could agree the terms of the license up front and include them in a term sheet as part of that option. So everybody knows what they're doing up front. We can't do that in the US because of the tax laws. Companies used to be pretty upset about that. I think they've come to live with it. Another option is they can pay a fee up front and get a fully paid up license.
Okay. Let me take on a couple of questions. I'll just request Shankar Rao Ganta. Can I take a few more minutes, Ashley?
Sure, we can have another 5 minutes or so.
Yeah, I'm unmuting you, Shankar Rao. Your question.
Thanks, Prem.
Yeah.
Thanks, Stevens. It's a great talk. My question is, while out-licensing from the universities, is that indemnity should be one-way or two-way, or representation or warranties, or the indemnity should be take care by university in the one-way or two-way? So what is the best way to cater that?
Yeah, I think the question is more about indemnities, reducing liabilities, and what kind of warranties assurance. You want to reiterate that, Ashley?
Yeah. So the university wants to guarantee as little as possible, because if things go wrong, then they will finish up taking legal action. So you don't represent that the technology will work. You don't represent that there's no dominating patents you're going to need a license to. What do you want in return from the licensee? Well, they have to represent that they're legally able to enter the agreement. They need to represent that they're in good standing. They paid their taxes. They need to represent that they are committed to developing the technology. But as I say, in the standard form of license agreements, I have what the representations of each side should be. And I'm happy to share those.
And would you say that I don't think in the case of universities, you'll have two-way indemnities, right? It'll be one way.
Correct. They're indemnifying the university if there's a lawsuit against the university.
Yep. Okay. Shiva, your question. I'm just unmuting you. Go ahead, please.
Yeah. Thank you, Premant. Thank you, Ashley, sir, for the inputs on the patent licensing. The question is about if we want to license to a country, say Canada, and we do not have a geographical patent over there, we just have a PCT. So how would that work? Like, can we go ahead and license in that particular country, or can we find a company which is wanting to in-license that patent and collaborate and go ahead? Which one would work better?
So this is a really important issue for universities because, you know, the patent system is very harsh. You have to do things by certain deadlines, and if you don't, it's gone. So you can, universities can spend so much money on patents that you need to be very disciplined. So you want to file a PCT to maintain worldwide rights. PCTs really are pretty cheap if you think about it. But then you only have a limited time period to convert that PCT into different national phase applications. Basically, you've got to have a licensee by 30 months or your rights to those additional countries go away. So that's why I say file a PCT and then try and find your Canadian licensee. And if you do before the 30 months is over, then certainly you're going to make Canada one of the nationalities where you perfect your patent rights.
Ashley, I think, Pragna, did you have a question, please? You posted something.
Yeah, Dr. Stevens, what we have understood so far from our experience is that many of the universities and institutes that we talk to, they have a mandate for doing non-exclusive licensing only. But there are companies who at the outset only, they want exclusive license for a technology. So how to navigate through these loggerheads, I would say, because they would say non-exclusive, they would say exclusive.
So my question is, first of all, why are they under mandates to do non-exclusive licenses only? This was the situation in the US before Bayh-Dole. The US government had a philosophy, well, we paid for the research that led to these inventions. No one company should get rich on the back of research paid for by all taxpayers. Now, that sounded very good on paper. In practice, it was a catastrophe because university inventions are very, very early stage. We don't have any proof of principle. We don't have any prototypes, nothing. The company's going to have to make a big investment to develop the technology and prove that it's going to work. And what incentive does it have to make that investment? If they're successful, their competitors can come along and get a license on the same terms. That was why university patents just didn't get licensed before Bayh-Dole. The government did the licensing. They only licensed 4% of the patents that they owned. And one of the big things about Bayh-Dole was it gave control back to the universities. They were still only allowed to exclusively license for 5 years. I think that was because the American Cancer Society, it would only grant exclusive licenses for 5 years. So for research it had funded. So that was one model was out there. Within 4 years, they came back and said, you can grant exclusive licenses for as long as you like. In the early days, about half of the licenses were exclusive. Today, it's down to about a third. We're doing a lot more non-exclusive licenses, but it's still very important to be able to grant exclusive licenses. So I would say to those institutes, you've got to change that policy. You've got to change it. You've got to have the freedom to grant exclusive licenses and to judge what's right for each technology. This one, it doesn't need a big investment. Fine, license it non-exclusively. This one needs a big investment. Then you need to be able to grant an exclusive license so that somebody has the incentive to make a big investment to develop that technology.
Yep. Actually, sort of an cheeky way to get around it is that some of these people may not understand what's a limited exclusivity. So you might want to position something in between, which gets away.
Exclusive by field of use.
Yeah. So you can limit the exclusivity and still call it non-exclusive, right?
Yeah.
Yep. Anyway, I think we have taken a lot of your time. Thank you so much. I don't want to, Pragna, can we close the event?
Yes, yes.
Yeah.
Thanks a lot, Dr.
Thank you,
Stevens.
Ashley. Yeah, this was wonderful. Great learning.
Okay.
We look
And
forward
tomorrow
to
we'll talk
tomorrow's
about
session.
how much to ask for.
Yeah.
Yeah.
Tomorrow's session would be very revealing for many of us. Thank you so much.
Okay.
Thanks a lot.
So I will share with you the standard forms of agreement.
Yes.
And I will also share a PDF of this talk. And
Yes.
feel free to distribute those to the attendees.
Yes. Yeah.
Thanks
So,
a lot.
Pragna, please do that. Yeah.
Yes, yes.
Okay. Yeah. Thank you very much. Thanks a lot,
Thanks,
Ashley.
Dr. Stevens.
Good night, everybody.
Yeah.
Bye-bye.
Good day, Dr. Stevens. Yeah. Bye.